Next, from the state capitol, we hear the testimony of attorney John Stevens, who represents the group We Are One Illinois, which is fighting to keep state pensions from being reduced. Mr. Stevens testified before the Senate Executive Committee. This runs about 7 minutes.
Good afternoon, Mr. Chairman and members of the committee. I am John Stevens. I'm an attorney with Freeborn & Peters, and for the past year, I've been working with the We Are One Coalition, providing legal advice and guidance on issues just as we've been discussing today. The police powers clause, police powers exception, has never been applied to the Illinois pension clause, nor has it been applied anywhere. When we talk about police powers, the example Professor Rosen used, you can't use free speech as an excuse to yell fire in a crowded movie theater. Justice Oliver Wendell Holmes made that point that mayhem would result. What we have here, however, is not public safety or police power issues at all. What we have are questions of funding. The state takes in money, it spends money. What we're witnessing is a change in fundamental priorities and how the state chooses to spend its money. The pension clause was put in 1970 Constitution to address that specific problem. In 1964, the Taxpayer Federation created a report outlining that our pension systems were about 40% funded, pretty much the same as they are today, and said, this is a real problem. Why was it a problem? Because under the law at that time, pension laws could be changed like any other law. Pensions were determined to be a gratuity. In the ordinary case, if you pass a law today, you can change that law tomorrow unless there are property rights involved. The 1970 Constitution was enacted specifically to provide those property rights. The Constitution, as Professor Rosen stated, is unequivocal, absolute, and from there we went on to listen to a description of how he would like the law to be rather than how the law has been interpreted. Under Illinois law, it is not appropriate to diminish pensions unless there's a contractual relationship that can be offer, acceptance, and consideration. Attempts at reducing pensions unilaterally have unanimously been rejected by the courts of Illinois and elsewhere. We're looking at a situation where the legislature, through its prior underfunding, took steps that it knew would reduce its contributions to the pension systems. When we talk about the ramp from 1995, which by the way was the second ramp, there was a first ramp in 1990 that didn't work either. It was redone in 95. The ramp is a nice way of saying we're going to determine what we owe the systems, but we're not going to give them that much this year because we can't afford to. We're going to push our obligations off to the future. Through the first 40 years of this debate, the legislature came to these questions saying, it's all right if we don't give the pension systems enough because we have a plan in place, we have a system, we will make good on our commitments to our employees and our retirees. It's only been in the last 3 years that we've heard folks come forward saying, if the law were to change, if the courts were to look at these questions in a completely new light, we might be able to impair existing rights and pension benefits and get away with it. I'm here to tell you that we've seen no indication here in Illinois or at the U.S. Supreme Court. In connection with the 2002 ERI, we encouraged our state employees to retire by pushing them from state employment into the retirement systems. The goal, the operating budget was in trouble. At that time, the pension systems were fairly well funded. State employees' retirement system, about 80%. Teachers, I think, was about 65%, much better than they were today. When the concerns were raised in the floor of this House and in the Senate about what will this do, the answer was, needn't worry, we've got a funding plan, we'll catch up, the plan is in place. After that, pension obligation bond legislation came through. Same questions, same answers. We will protect the benefits of our retirees and our employees, the Constitution requires it. Same thing when the pension holidays legislation came through in 2004. What was the solution? We stopped paying money to the retirement systems because we didn't have it in our pension or in our budget, leaving it to pay another day. Now that that day has arrived, we see the legislature looking to change pension benefits on an emergency basis. It's hard to see how this succession of intentional acts can lead us to an emergency situation today. Certainly we need to make tough funding priorities and tough funding choices, but let me close with a statement, a quote from the United States Trust Company versus New Jersey in 1977. A state cannot refuse to meet its legitimate financial obligations simply because it would prefer to spend the money to promote the public good. Now, we've heard the governor talk about fully funding the MAP program, fully funding veterans' homes, all laudable goals. But if that comes at the expense of pensions and pension benefits, I'll continue with my quote. The state cannot refuse to meet its legitimate financial obligations simply because it would prefer to spend the money to promote the public good rather than the private welfare of its creditors. In this case, the pensioners, the employees are your creditors, created through a contract embedded in our Constitution. We're asking you to uphold that commitment and uphold the Constitution today. Thank you.
You're watching the Illinois Channel.